the object of the Act, its scope and relevant concepts. The Act passed by central government aims to provide social security and timely monetary assistance to industrial employees and their families. The Act applies to every factory engaged in any industry and other establishments as specified in Schedule 1 to the Act and where 20 or more persons are employed. And it also applies to those industries and establishments as notified by central government from time to time. However, it doesn't apply to a cooperative society, and it also doesn't apply to an establishment permitted by EPFO to have their own internal schemes which are considered to be similar or better than the statutory schemes. The monthly pay under the Act includes 4 components: basic wages, dearness allowance, retaining allowance, and cash value of food concessions. The term employee covers only persons employed in the normal course of business in or in connection with a factory or establishment. It includes those employed through a contractor. It may include a sweeper, watchman and a gardener, but it excludes an apprentice, casual employee or anyone employed for a short duration or for a contingent vacancy. And it also doesn't include an employee whose salary exceeds rupees 15,000 per month when the Act applies to an industry or establishment for the first time. Every employee is required to be a member from the date of joining. Once an employee is a member, he continues to be a member even where subsequent to his joining his salary exceeds the ceiling of rupees 15,000 per month. What is crucial is the employer-employee relationship for coverage under the Act. Employer in respect of a factory means the owner or occupier of the factory. It includes the agent of such owner or occupier, and it also includes the legal representative of a deceased owner or occupier. In respect of any other establishment, it includes the person having ultimate control over the affairs of the establishment. Employer is also called an occupier, and it includes MD, manager and CEO. The Provident Fund Act has 3 major components: Employees Provident Fund Scheme, Employees Pension Scheme and Employees Deposit Linked Insurance Scheme, the 3 components. Employee Provident Fund Scheme forms the major component of the Act. The scheme envisages contribution to EPF account based on monthly wages of an employee. Every employer liable to pay 12% as his monthly contribution, which is apportioned between Employee Pension Scheme 8.33% and Employee Provident Fund 3.67%. An employee is required to contribute equally with the employer, but his contribution goes fully into EPF account. He may pay more also voluntarily, and it is the duty of employer to deduct employee's contribution and remit the aggregate amount by 15th of the following month. The Employee Provident Fund Organization of India EPFO implements the EPF scheme. Its board of trustees invest the funds from the contribution as per plan approved by central government, and the return generated is given to members as annual interest credit at rates finally decided by the government. For EPF 21-22 financial year, interest was 8.1% and the previous year it remained at 8.5%. Funds lying to the credit of an employee are permitted to be partially withdrawn subject to sublimits and terms. The purposes include medical, marriage of children, education of self and child, purchase of land for house construction, construction of a house, home loan repayment and house renovation. The Act permits withdrawal up to 90% in a special case within 1 year before retirement and the age to be not less than 54 years. Complete withdrawal is allowed on retirement, death, permanent disability, superannuation or retrenchment. Employee Pension Scheme is the second component of the Act. Employees enrolled with the Provident Fund become members of EPS automatically. Government adds 1.16% to the contribution of employer. For getting pension, one has to put in an aggregate service of 10 years. Monthly pension made available from 58 years of age until death. Where a person is not able to accumulate the minimum service of 10 years, he is permitted to withdraw accumulations under EPS and EPF schemes. Pension is also payable on permanent disability, superannuation and completion of 58 years of age. The monthly pension formula is pensionable salary into pensionable service divided by 70, and pensionable salary is monthly basic plus DA averaged over last 60 months of service, and pensionable service is years employed till retirement, and the number is capped at 35 years. In the calculation of service, 6 months and above rounded off to 1 year and less than 6 months is ignored. The third scheme under the EPF is employee deposit linked insurance, which gives assurance benefit to the nominee of an employee. EDLI offers financial support to families in case of demise of the member. Any employee who has an EPF account becomes eligible automatically. No requirement to pay any premium for the employee. Employer contributes a nominal amount of 0.5% of rupees 15,000 or rupees 75 per month. Nomination under the EPF Act is considered as nomination also for EDLI. EDLI insurance benefit is payable for death after a service of 12 months payable to the nominee. Comprises two components. One is 30 times the average monthly wages with a ceiling of 15,000 per month for the preceding 12 months, and 50% of average balance in EPF subject to a ceiling of 2,50,000. Both put together, the minimum compensation is rupees 2.5 lakhs with a ceiling of rupees 7 lakhs. Employees Provident Fund provisions regarding complaint, redressal and recovery. Provident Fund Commissioner is the authorized officer with the power to determine the amount due from any employer. Employees Provident Fund's Appellate Tribunal hears appeal against order passed by the authority. If a company goes into liquidation, its employees have first claim on its assets for their EPF dues. Credit of any member in the fund is not liable to attachment under any decree or order. No employer to reduce entitlement per terms by reason only of his liability under the Act. In Regional Provident Fund versus Vivekananda Vidya Mandir and others case, the Supreme Court has given a decision in 2019 which is pending for implementation. It said special allowances to form part of basic wage while making PF contribution calculations. Monthly pay shall include basic DA retaining allowance, value of food concessions plus special allowances. Special allowances are those paid at fixed rate such as education allowance, conveyance allowance, telephone allowance, etc. But variable allowances payable only to a particular category of employees is not a part of special allowances. Object and scope: 3 schemes under the Act: Employee Provident Fund Scheme, Employee Pension Scheme, Employee Deposit Linked Insurance Scheme and miscellaneous provisions. Progress review on Provident Fund Act. Where 20 or more persons are employed in an establishment, the EPF Act becomes applicable. Once applied, the scheme or the Act shall continue to apply even in a case where the staff strength falls below 20 subsequently. In case of cinema and theatre, instead of 20 or more persons, the number of persons required is 5 or more for applying the Act. A special provision in case of tea industry, it is covered under EPF Act. In case of Assam, the government has set up its own separate Provident Fund scheme. EPF is not applicable to a cooperative society. It is not applicable to an establishment set up by central government or state government with similar schemes, and it is not applicable to establishments which are permitted to have their own schemes under approval from Employee Provident Fund organization, and certain establishments which are exempt by central government by notification. And central government can also exempt an establishment based on the financial position of that establishment on a case-to-case basis. An employee is required to become a member from the date of joining the employment. At the time of joining, if a person's salary is above 15,000, he is an excluded employee. He will not be included under the scheme. At the time of joining, it should be less than 15,000 or equal to 15,000. Once an employee is a member, even if his salary goes beyond 15,000 after he joins, he continues to be a member. It doesn't stop. But while calculating his contribution will be calculated on a maximum of 15,000. The Act applies to all regular employees, but it doesn't consider apprentice. If the number of
staff in a company is 20 or more, once the PF Act applies, the contribution to be done by employer is 12% and employee also will pay 12%. If the number of staff is less than 20 employees, the company or employer has to contribute 10% and employee also contributes an equal. The employer makes 3 contributions. One, he contributes towards PF. His PF contribution is 12. He contributes towards EDLI, it is 0.5%, and he contributes towards administrative charges 0.5%. Employee contributes only towards PF. Employee also contributes 12%. And whatever 12% paid by the employer, it is split into 2 components. 3.67 is Employee Provident Fund EPF and the balance is transferred to Employee Pension Scheme. The contribution of employer to EDLI, as we saw, is 0.5% of the monthly pay. 0.5% of 15,000 ceiling is 75 per employee. Minimum administrative charges. If there are hardly any employees, he has to pay 500 per month per establishment. The contribution to the fund has to be remitted within 15 days. Where the employer has his own employees and also employees hired through contractor, the employer is responsible to pay both contributions from his side and he can recover from his contractor separately. Whenever an employer has got an appeal against any demand, his job is first to deposit at least 75% of the amount due as determined under the Act and then file an appeal under EPF Appellate Tribunal. And when a person is transferred from one employment to another or he changes an employment, balance in his credit is transferred using his universal account number under the system automatically. PF is allowed to be withdrawn partially by the employee subject to conditions, and the purposes are: it can be medical purpose, marriage of self and children, education which is post matriculation, purchase or construction of a house, home loan payment or house renovation. Pension is available for the persons under EPF, but the minimum service of 10 years with an organization. The organization may be one or more. If a person works even after he attains 58 years of age, his pension contribution which the employer makes, the employer need not contribute towards EPS once the person crosses 58 years of age. He can continue in service. The employer, just because he pays for EPF, pension and EDLI, he cannot in any way deduct or reduce the wage levels of the employee. The pension fund at the national level is managed by the central board, and the central board is assisted by an executive committee which is once again appointed by the central government.